It's great to have American elections attorney Marc Elias back on the program, also founder of Democracy Docket. Marc, listen, we've been covering the Supreme Court decisions of Monday and Tuesday. We've been covering demands for legislation like the Save America Act, which would impact elections. The big picture is it's all seeming pretty bad to me, and I don't want to we're at a time that sometimes we say we're getting ready to celebrate and we're going to cookouts and we're doing these different things. The state of law in the United States right now is seeming not so good. Can you give us like a 40,000-foot view and then we'll drill down on some specific areas?
Yeah, I think that you have to look at this from two different perspectives simultaneously. Okay. So, on the one hand, as you say, the recent Supreme Court term, taken as a whole, is a harbinger of not great things, right? I mean, the cases that were lost were important cases for rule of law and the Constitution and democracy. We could start with the Calais case, which gutted Section 2 of the Voting Rights Act. You could go to the case that we just saw involving Donald Trump's ability to fire the commissioner on the FTC. You could look at some of the immigration cases and say things are really not great. And frankly, you could look at even some of the cases we won. The voting by mail case that my law firm and I were involved in winning. It was 5-4 on a proposition that frankly shouldn't have been that close. And probably most disturbingly, the birthright citizenship case, which remember when Donald Trump issued his executive order on day one about birthright citizenship, the working assumption was that it was not just unconstitutional, but it was damn near sanctionable for the lawyers at the Department of Justice to defend it. And in fact, several of the early federal courts that reviewed it questioned the legal ethics of lawyers even defending it. And yet what we saw was a decision that came out the right way, but was quite narrow. I mean, it's reported as 6-3, and that's technically true. But if you look at just the constitutional question, it was really a 5-4 decision.
Right.
So, there are glimmers of good, right? In that you could say a win's a win, and it doesn't matter if it's 5-4 or 9-0. But as you look out on the horizon, this is a court that is not a friend of democracy.
When you look at Watson v. RNC, this case that did go your way, having to do with whether ballots have to come in by election day or be postmarked by election day, we talked about this one with me as a layperson, as a non-lawyer. And it seems to me that the only consistent standard, because we don't necessarily know how long a ballot will be in transit, the only logical consistent standard would be if you filled it out and mailed it by election day, it counts. And then it might take a day or 2 days or whatever to get in, but that's the consistent standard. What were the arguments being made by opposing counsel as to why the ballots shouldn't count, even if the individual has done their part, the voter, by filling it out and submitting it by the day of the election? And why did the court reject those arguments?
Yeah, so this is actually a good example of both the good and the bad about
Yeah.
the term, right? Because the good is that, as you say, the Supreme Court rejected these arguments. The bad is that four justices of the Supreme Court actually would have thrown out those ballots, which would have been hundreds of thousands of votes, upwards to 1 million votes
Yep.
would have been thrown in the trash. So the argument that the Republicans made, because it was literally the RNC that brought the lawsuit, was that the federal election day statute that says that the election day in the United States for federal elections is held on the Tuesday following the first Monday in November, that requires all the ballots to be in by that day. Now, if that seems like a non sequitur, it is a non sequitur. Like if it seems like a thin reed upon which to build an argument to disenfranchise hundreds of thousands of voters, you're correct. Like you're not missing anything else. There was nothing more nuanced to this argument other than the election day statute. And yet, you saw, like I said, a 5-4 decision. The plus, the good part, well, the 5 came out the right way. The bad news is that, the 4 justices that found otherwise, and when you read their arguments, it is both a combination of selective sort of pseudo history cobbled together with policy arguments. And, to be honest with you, David, what you say is right. Like common sense says the consistent thing is when the voter relinquishes the ballot. The practice in the United States with filing tax returns and other things is that postmarks are what matter.
Right.
But, I'll be the first one to say Congress could pass a law that that says otherwise. But here's the thing is it hasn't. It hasn't. And so the fact that some of the justices on the Supreme Court wish that Congress did or had or would, is not judging. That isn't the role of judges. And that is part of what is the unifying theory of this term, is that the Supreme Court over and over again interposed its judgment for the judgment of Congress. And then people wonder why it is Congress is so inactive in defending democracy. Well, I'm not here to defend Congress, but part of it is because the Supreme Court, when they do defend democracy, the Supreme Court decides that they can't defend democracy.
I, along with several other creators, were put on this new White House media offenders list. Does the list alone, in and of itself, seem to you like unconstitutional state retaliation? Or is the existence of the list itself okay, but taking some subsequent steps would not be okay?
Yeah. So first of all, I both offer my congratulations and my regrets
Yes.
that you are on the list, right? Like the fact is that it is a sign that you are effective, and it is a
Right.
sign that you are doing your job. And frankly, I wish more people in the legacy media were as doing their job as effectively as you are doing it. So I just want to state that at the outset. As a legal matter, I mean, there's two sides to this coin. The first is that the government would say that it has a right to speech, in other words, it has a right to say its view. And to the extent all it is doing is conveying speech without any threat, without any actual real retaliation or anything behind it, it's allowed to say we don't like David Pakman in the same way that it can say it doesn't like the law firms, right? It's the actions that they take. So I think that is certainly supportable in the case law. On the other hand, it is hard to square this White House's enemies lists with the idea that it is pure speech, because we have in fact seen them repeatedly take action. So one of the ways you judge whether a threat is a true threat, in other words, it is actionable versus just speech, is contextual. And if you had an administration with no history of weaponizing government against political opponents, I would feel pretty confident being like, look, this is just the White House spewing off that it doesn't like you. On the other hand, this is a White House that has shown, and a president that has shown, that these statements are oftentimes acted upon through action, and therefore it can rise to the level of a true threat, because it is no different than the mobster coming to your store and saying, it would be a shame if something happened to your store.
Right.
And, on the one hand, they could say, well, look, that's just speech. But if it turns out that the last 4 stores they visited got burned to the ground, now that takes on a different context. So I think that it is, I think it is part of a effort by this administration to intimidate and to convey real threats.
What should those on the list and those who may one day be on the list be doing, if anything?
Look, I think the most important thing people on the list should be doing is what you are doing, which is you are not backing down. You are rising up. You are not self-censoring. Instead, you are charging forward. And this is the great tragedy of our time, is that when democracy needed people, when the First Amendment was under challenge, the people with the most, the people who had all of the resources and all of the assets and all of the ability to stand up and fight back, they are the ones who retreated. And it was people like you, David, who didn't do that. You didn't back down. You stood up strong and tall, and you continued to speak the truth. So I just want to say that is the first thing you should do. In terms of whether you do more than that, whether you decide to bring legal action against the administration or not, I have made the decision in my own case, where he threatened me. I'm just going to keep speaking out, and that'll be enough for now. But I
Right.
mean, ultimately, that is a personal decision.
One of the areas we are actively all focused right now, and your law group is heavily involved in, is the Republican strategy to suppress voter turnout in these midterms that are now 4 months and a couple of days
Yeah.
away. I guess so far, Trump's not really getting very far with the Save America Act. He tried to hold the housing bill hostage unless they would pass the Save America Act. They don't seem to have the votes. But it seems as though at the state level, they are going full speed ahead with everything they can get away with. Can you kind of give us the lay of the land as to what's going on and what you're doing to try to stop it?
Yeah. So, Donald Trump has a familiar pattern. He engages in irresponsible rhetoric. Then he tries to escalate it through legislatures. Then when that fails, he goes to court. And when that fails, we have violence, right? So in 2020, there was rhetoric. He tried to get state legislatures to do something, as you recall, or state officials to do something. He famously called Brad Raffensperger to find votes that didn't exist. When that failed, he went to court. When that failed, we had January 6th. So, the rhetoric is all around, right? Donald Trump has been clear now for months that he is going to try to undermine free and fair elections this November. Then we saw the legislative actions. And as you point out, it is his effort to try to pass a federal bill, the Save America Act, that would disenfranchise voters. That has failed spectacularly and continues to fail spectacularly. He has also tried to inspire state legislatures to pass mini versions of that, and some have, and we have sued those states, and those cases are ongoing. But then he escalated beyond that and went to court. And these are the cases that the Department of Justice has brought against 31 jurisdictions, 30 states plus DC, to try to access the most sensitive voter information that states maintain on their citizens.
Yeah.
Their name, their address, their social security number, primaries they voted in, general elections they voted in, all partisan registration, all this stuff. And my law firm and I, we have intervened in all of those cases. So far, Donald Trump is 0 for 11 at the trial courts. He is 0 for 1 at the Court of Appeals, so he lost 11 cases in states. They appealed Michigan to the Sixth Circuit, a pretty conservative circuit, and they lost there. But these cases continue. I've said that these are not the last losses that Donald Trump is going to have. I suspect he will go at least 0 for 15 before anything, happens. He could go 0 for 31 for all I know. But these are now going to turn to other courts of appeals where there are appeals pending. And I feel pretty good about how those are going.
Final thing I want to ask about. At the end of all of this, there's the fear, I guess we would call it, of Donald Trump declaring some kind of national emergency. That's a phrase that's often used. What does that mean, if anything, legally? And what power would that actually give him over any of the election infrastructure, given that the election infrastructure really is run by the states at the end of the day? Like, would that even do anything?
Yeah, it's a really important question. I'm so glad you asked it. A very smart question. So people conflate a lot of different pieces of this together. So let's
Yes.
start with the basics, which is where you ended, which is that the Constitution gives the states the constitutional authority to set the time, place, and manner of elections and to conduct those elections. So the president has no role. Congress, through appropriate legislation, can override this state decisions in many instances. But again, Congress hasn't done that. So the question is, against that constitutional framework, what can Donald Trump do? So one of the things you oftentimes hear is, will he invoke the Insurrection Act? The Insurrection Act is like a draconian law. It is not something that the president should invoke here. But I actually don't think it gets him very far, because what the Insurrection Act allows is for him to deploy the U.S. military, the standing military, not the National Guard, but the standing military, to conduct law enforcement. Essentially, it turns them into the police force in the United States. I think what Donald Trump learned from the point of the deployment of some active duty military in California, if you remember, in Los Angeles,
Yeah.
through Chicago, Portland, and Minnesota is actually the military is way too disciplined for his taste. It is way too law abiding for what he wants, and I think that's why at the end, like he was happy to have ICE and CPB in Minnesota, right? Because like they were willing to actually do things that I suspect like the uniformed military were not willing to do. So I don't think the Insurrection Act gets him all that far. In
Okay.
terms of a general state of emergency, the other thing you sometimes hear is, well, will he try to suspend the writ of habeas corpus? This is a right of all people in the United States, and I use the word people advisedly, like it is a right of anyone present physically in the United States to go to a federal court and say, I am being held unlawfully without probable cause or an arrest warrant that has been signed off by a judge or whatever it is, right? It is a way to prevent the arbitrary detention of people in the United States. Donald Trump cannot suspend the writ of habeas corpus. I don't think the courts would abide by him. He could try, but I don't think the courts would abide it. I'm not sure if you'd even get local or federal officials in all instances to abide it. So then you just get to the general question, David, of what if he just says, I am Donald Trump, and I just think there's an emergency, and so I am sending in the FBI, I am sending in ICE, I'm sending in
Yes.
CPB. Maybe I even make, ATF, I deputize them. Like, I just take all of the federal law enforcement agencies and try to use them to disrupt the elections. And I think that is the thing that we are all most worried about, people like me, because it's not so much that like this decree is anything other than a press release on letterhead from the White House, but he is sending federal officials to do things to disrupt elections. And I think that all of us need to be prepared for that. The lawyers need to prepare to go to court and call and prevent that. Voters need to understand their right is to cast a ballot, and whether there are people, from federal law enforcement. I mean, I always say this: if there's a federal law enforcement at the polls in my local jurisdiction, I'm going to go vote no matter what. And I think we all need to be prepared that the elections may look a little bit different than they've looked in the past, but we're going to do everything we can to prevent those kinds of actions. But we can't let them stop us.
That's for sure. Important work being done by elections attorney Marc Elias, also founder of the Democracy Docket. Marc, always really appreciate your time and your insights. Thank you.
David, I love your show. I subscribe to your channel. I even get alerts. I've hit the bell to make sure I get alerts when there's new content. So I hope everybody does that. Thanks for having me.
That bell will be the death of us, or not, or not. That's the important message. All right. Thanks, Marc. Talk to you soon.